coming to see our panel this morning on the ePrivacy Directive and the interplay with the General Data Protection Regulation. I'm sorry that we're starting a little bit late, but I assure you we're going to have 1 hour for the panel. I'm sorry we're going to eat a little bit into your coffee break, but hopefully we compensate with some cookies that we're going to be bringing to the discussion, I'm sure. So today we would like to discuss the ePrivacy Directive and the interplay with the GDPR. And for the ePrivacy Directive, we know in different countries, it's the responsibility for enforcing the ePrivacy Directive is with different authorities. It's not always with the data protection authorities. Whereas in other countries it is, both the GDPR and the ePrivacy Directive, same authority. At the same time, in those countries, the one-stop shop mechanism that we have on the GDPR doesn't apply in this area. And we have heard over these discussions yesterday already all the different issues and benefits that the one-stop shop can bring. So there's the discussion of whether the one-stop shop would be a good thing or a bad thing where it's applied to ePrivacy. And whereas, while it doesn't apply to ePrivacy, whether ePrivacy is a way of addressing the shortcomings that we have with the one-stop shop. And all these discussions in the context of course, we are discussing since 2017 the proposal for the ePrivacy regulation, which would completely change at least the governance system in terms of the ePrivacy rules. So we wanted to discuss all that today, and we have a very distinguished panel with great speakers. And I actually was so into the discussion, I forgot to introduce myself in the first place. So I'm David Martin, I'm the team leader for digital policy at BEUC, the European Consumer Organization. And I'm just going to introduce the speakers starting from the far end. Arwid Mednis is the head of public administration research at the Faculty of Law, the University of Warsaw, also a legal practitioner advising companies and institutions on these issues. Karin Kiefer, who is leading the Rights Protection and Sanctions Directorate at the French Data Protection Authority, the CNIL. Alberto Di Felice, who is Director for Infrastructure, Privacy and Security Policy at Digital Europe, representing the digital industry. And Ms. Birgit Sippel, who is the member of the European Parliament of the Civil Liberties Committee, leading the Parliament's work on the ePrivacy regulation proposal, among other things. So thank you very much for joining us this morning. I wanted to start the discussion with Karin, asking her a question, because the CNIL, the French DPA, has a strong track record in enforcing both the ePrivacy rules and the GDPR, because you are one of the authorities that actually has responsibility for both. And we just wanted to hear from you, how do you approach, what's your approach to enforcement? How do you see the interplay between the two? And also, do you see them as complementary or alternative routes for enforcement? Thank you. Floor is yours.
Thank you, David. Can you hear me? It's fine? Okay. I'm very happy to be here to share with you our experience. Indeed, we are competent both for ePrivacy and GDPR. We have enforcement power since 2004. In particular, on cookies, we are competent since 2011. We have quite good experience on this topic now, and we indeed last year issued many sanctions. We adopted 15 penalties last year for an amount of 214 million euro. We also have adopted more than 135 orders to comply. Those are formal notice to issue to the data controller to comply with the regulation. And on the topic of ePrivacy, to make the focus on ePrivacy and to focus on on cookies, we have decided to launch a very big action plan 3 years ago in 2019 to first to update previous guidelines that we had after GDPR to help the sector to give them some practical recommendation on what was expected from them on the cookies requirement of the consent requirement. We also adopted new guidelines. It was a very important work with the civil society, in coordination with civil society, in coordination with professionals, to discuss and to adopt those documents. And then, secondly, we started to control. So we made more than 90 online investigations on high traffic websites. It was a very big campaign of controls. And after that, we issued we adopted more than 90 orders to comply, for what we call formal notices to comply. We wanted to focus on a very specific point, what is the free consent, and the fact that when you give your consent on the website for cookies, you need to be free to consent, and that then there is a need that there is an equivalent possibility to accept, but also not to accept, and or to refuse. So it was the focus was on that point. We also adopted several sanctions on cookies. 4 sanctions, but in particular the major of them against Google and Facebook last year. And so this very important work was very lead to very good positive results. We can see now many changes on the sites that we control. We have an observatory of cookies, and we see that there are less cookies without prior consent. So it's a good thing. We intended to meet very strong expectations of the internet users who are increasingly sensitive on those topics. We have received more and more complaints about cookies, 250 last year, that reveals and show that it is something that is important to them, but it's only one part of the work, and it is complementary to all what is done every day on the GDPR aspect that is very present and more present actually, because even if we have many complaints on ePrivacy or on cookies, actually it's a small part of all the admissible complaints that we receive. We have 40,000 complaints each year, and 9,000 complaints are admissible. So you see that only, I say only, it's not to minimize, but 250 complaints on cookies comparing to the 9,000 complaints on other issues or topics. And so in the scope of our investigations as well, ePrivacy is only one aspect of what we check. When we make online investigations, so we check if the user, how the cookie are deposited, and how the user can consent. But we have it's only one aspect of our investigation, and we have actually much more cases and much more investigations on GDPR aspects. So it's really very complementary. We are also make investigation on the respect of the Post and Electronic Communication Code, because we are also competent on this aspect for the consent prior electronic advertising. And so we have mixed breaches in mixed cases.
Okay. All right, so I'll come back to you to ask you a follow-up question afterwards about how you specifically deal with all those issues when you have one investigation, for example, that touches upon all of these different aspects, where you draw the lines and how that flows afterwards. But I wanted to jump to Arwid, because you explained a situation, a scenario where you are competent for everything, basically, so you can take a comprehensive and holistic approach to things. But in Poland, where Arwid is working, the situation is a bit different, because you have the Telecoms Authority on one side and the Data Protection Authority on the other one. Mm-hmm. So I wanted to ask you, Arwid, how is it working? What's your experience in Poland with the ePrivacy directive and GDPR?
Yes, thank you, David. Can you hear me? I hope so. First of all, thank you very much for the invitation, because it's good to see you after last time I was 3 years ago, so it was before the pandemic in Brussels. So it is good to see you in real and not virtual form. Yes, as you said, Poland is, unlike France, is an example of a country in which we have two separate authorities. One's DPA's President of the Office for Personal Data, and the second one is President of the Office of Electronic Communications. And of course, is naturally the authority competent in all this regulatory area in telecommunications sector. Both authorities have many instruments of intervention in privacy and data protection. For example, as we speak about penalties, the maximal penalties provided by the law are quite comparable, because in the GDPR we have up to 4% or 20 million euros, and in telecoms law it's up to 3%. So there is a question whether the activity can be compared. If we analyze the cases in which GDPR and ePrivacy overlap, we can see big differences between the Polish DPA and Telecommunications Authority. Let's take the example of cookies. Assuming that the cookies are personal data, in such cases the Data Protection Authority is much more active in Poland than the other one. Our DPA carries out explanatory proceedings, issues decision, while the Telecoms Authority is less active. Frankly speaking, I haven't heard about any decision regarding cookies from the second authority. In one of the cases, I was representing a client, a case related to leak of data, the leakage of the personal data of subscribers, so it's also covered by ePrivacy law. The Data Protection Authority led the proceeding, asked the questions, right, and tried to explain the situation, and finally issued decision with in Polish circumstances is quite the penalty was quite high, while the Telecommunications Authority limited itself to asking few questions, and the proceedings ended here, and there were no further consequences. I'm not assessing the legal side, whether the penalty was justified or not, because it's still in the court of the first instance cancelled the penalty. But I'd like to show that there is a gap in application, gap of a level of activity of both authorities. So huge penalty, and I don't want to say that our telecom authority does nothing. It wouldn't be true, because they are very active, for example, in all this area of unsolicited marketing. But in the area like cookies or leakage of information, they are not so active. Of course, there is a doubt whether here, in this case of leakage, there is a doubt whether an entity, an entrepreneur, can be punished twice for the same act. But on the other hand, we may say that our DPA, which is good, focuses mainly not on the leakage itself, but on whether the entity was prepared, assessed the risk, etc., and how they mitigated the risk. The last example shows the lack of cooperation between the authorities. A few years ago, I attended a meeting between 3 authorities, in fact, the DPA, Telecommunications Authority, and our Anti-Monopoly and Consumer Protection Authority. And the meeting concerned specifically the issue of unsolicited electronic messages. And I remember that all the participants, including entrepreneurs, lawyers, etc., were really surprised by the fact that representatives of each of these bodies spoke in a completely different way about the legal qualification of such marketing and the way a given body approaches these issues. One of them said, no, it's completely legal. The second one said something, it is partly legal, and the third, it is absolutely legal. So the lack of cooperation, lack of consistency in this area. I think we will come back to this later when
yes, exactly.
we'll come to the conclusions. So
I was about to tell you that. So yes,
yeah,
I think that a lot to unpack in your intervention, especially yes, about lack of cooperation, consistency, and other issues in regards for the different finding powers, for example. So we will come back to all that. I wanted to turn now to Alberto. So normally the industry has been supportive of the one-stop shop mechanism. It's one of the benefits of the GDPR, let's say, that you only have to deal with one authority as opposed to 27. Now, for the ePrivacy directive, you don't have that. So you actually have to deal with normally, well, depend on the country, but 27 different authorities when it comes to that legislation. And we hear now that there's differences in how it's applied and interpreted. So I have two questions to open. First of all, how do you approach that? What issues do you see there? And second, whether you would say that extending the one-stop shop for ePrivacy rules, as it's proposed in the ePrivacy regulation, would be a good thing or a bad thing?
Thanks a lot. Can you guys hear me? I'm going to be the fourth person to ask because it's very difficult for us to hear ourselves and the other speakers, so that's good. No, I think one of the starting points for us, and I'm going to go back and forth between the directive and the proposal, because the starting point for changing the enforcement model for us as industry is, in a sense, purely logical. I know that everybody likes to think that they're logical, but one of the mantras of the new proposal, the regulation, has been that ePrivacy is lex specialis to the GDPR. So if that's the case, well, clearly the enforcement model should be the same. You can change a lot of things, but the enforcement model should be the same. And so we would clearly like to see that extension for the same reasons that we have been favoring the one-stop shop model for the GDPR, which is clearly that from a company perspective, from a data processor controller perspective, that provides more legal certainty and you know more or less what you're dealing with. Because compliance for GDPR and one new regulation in particular, ePrivacy, is not an easy thing. And you know, everybody has to deal with GDPR. So everybody benefits from knowing what the authority and what the system that they're dealing with is. The situation with the current directive clearly is much more of a patchwork, and Arwid, you know, explained some of the issues there that maybe we can expand on later on. But it is certainly not an ideal scenario for businesses, because it effectively, let's say, multiplies the attack surface, and more broadly, you know, it exposes companies to effectively double jeopardy. And as we see, you know, having more than one authority potentially responsible for punishing the same type of behavior, while it may be, you know, statistically good for people like BEUC, because, you know, the more fines you get, probably the happier you are. Clearly, from a company perspective, that's not ideal. So we like to avoid that.
Well, we want to say changes in practices plus fines, not only the fines are necessary. Thank you. Thank you very much. So turning to you, Birgit, we have heard about the issues that there are with the ePrivacy directive as it stands. We hear from Karin that there are not that many complaints actually from people about ePrivacy, and at the same time we are discussing this new regulation since a long time now, and to the extent that some people actually wonder whether it will be adopted in the end or not. Hopefully it will. So I just wanted to ask if you could basically remind everyone why ePrivacy rules are important and why the regulation itself is also important.
Okay, thanks a lot for that. And I was wondering when I received your invitation, and thanks for that, if you would like me to talk about all the details of the regulation, like the OTTs, the famous Article 10, the cookie walls, everything else. But I could imagine most of you are well aware about all these details. So I would first like to start with another point, and that is the question, why is ePrivacy regulation so important? And to be honest, I think you mentioned it in the beginning, we are coming from the year 2017. So I would have hoped, being now in the year 2022 even, that it's no longer necessary to talk about why it's important, but we could talk about, hey, we have it, great, let's ensure we implement it and even improve it. But still, after 5 years, we are talking about, should we really have it? So, and I think after these 5 years and looking into all the developments around digitization, artificial intelligence, I'm tired of listening to some of the actors say, oh, the rules that are there in the analog world should also be there in the digitized world. Sometimes I like to create pictures to remind us to the old world, but it's not true. We are talking about the protection of confidentiality of communication. And with all the developments I just described, today it's much easier for interested people to go into my communication than before in the analog world. Before that, if everything is done on paper, your letters, memos, minutes, notices, how difficult would it be to get all those papers, to get a picture of what you are doing and thinking? But now in this digital environment, simply because it's possible, it seems that too many people, too many actors, too many business believe it's technically possible, so why shouldn't I dig into all your privacies? And no longer respect confidentiality of communication. So there are differences between the analog and the digital world, and we shouldn't forget about that. And as I said, with all the developments in digitization, artificial intelligence, so-called intelligence, Some even call it artificial idiocy because the damages can be very big. So it's even more important than ever. And to be honest, if I look around, I'm tired of having so many different actors in different institutions from the business. All of them like to talk about, yes, we are so happy we live in a democracy, we have the rule of law. Yes, of course, fundamental rights are important. But then if you go to describe the rules to make sure these general rules really apply in practice, then you have the impression that at least two things are always more important than protect fundamental rights. It's business interest, and on the other hand, it's law enforcement. Law enforcement also wants to collect all our data. And in the end, you might say I'm going a little bit too far, but we are not even in the first starting points. You have to think it from the end. If everything is possible and everything more or less is allowed, not only with one legislation, we now have a lot of legislation in different areas where always digitization is being a part of it. And talking about law enforcement, we might end up with a situation where every single citizen is seen as a suspect. Oh, you could become a criminal one day, so let's collect data. And data retention also is partly a part of the new regulation, at least in the proposal of the Council. So I wanted to make this political point very, very clear. In these times, it's ever more important than ever before to protect confidentiality of communication. It's a fundamental right. And it's also a fundamental right that is important for other areas. It's not only that maybe you and me would like to have your private interest being protected, your family interest, but protecting confidentiality of communication also means to protect other fundamental rights, like diversity of expression and media. So to be able to criticize your government without everybody is following it or putting pressure on you or finding out where you are. So if really we as European Union would like to keep up this image that we are a union of values, we are democracies, we are protecting our citizens' fundamental rights, then the ePrivacy regulation is more important than ever. And going to the details, I think I will not talk about OTTs, so to make sure that the rules to protect confidentiality are not only there for telcos, but for everybody who is offering something in this digital world. I may not that much talk about Article 10, meaning privacy by design and default. It should be there, because it's so easy, I hear it again and again, to say, oh yes, but there is a possibility that you protect your privacy. It's on the user. You can go there and do this and this and this, and then you also have to ensure these technical points to make sure your privacy is protected. Why should I do it as a user? I have sometimes the impression that in this digital environment, I have so many things to organize to protect myself that I have no time to do my real living. So why not say it's privacy and privacy by default? So the technicalities, the browsers, the apps are created in a way that they do not, as a general rule, allow for the cookies. It should be there. And a final point, and I'm happy to come back maybe some other details later if you are interested in that, the cookie walls. Why is it that they are still there? By the way, we could have fight back that in the combination of ePrivacy directive together with GDPR, if only, not only data protection services are going behind, we could have even together with the Commission organized some more infringement procedures to avoid this, because after GDPR, clear consent is needed. And you still find internet pages where this is not respected. Sometimes you find, oh, you have to go into the details, and there you will find a way to adapt, and then you go to those, and you never find any button to say, no, I don't want to have cookies. So to finalize my hopefully short introduction, and once again, nevertheless, give an example to the online world. If I want to buy a ticket for a train in the old world, I went to the station, I said I would like to have a ticket, I pass my money, I get the ticket, that's it. That's it, nothing more. But please imagine, you go to that counter, you buy a ticket, you give the money, you get the ticket, then you leave the place, but someone from that station is following you to find out if you may buy tickets in another place. And by that, you enter another shop, so suddenly another person is following you to find out what is it that you are doing, what you are buying. And step by step, you are going through your town, and ever more people will follow you trying to find out what you are doing. You mind that's crazy, but that's what's happening with cookies in the online world. Everybody is following you. So coming back to some business models say, oh, but all with these privacy rules, some business models will not survive. Okay, then that's it. Please look for other business models. Before these new possibilities, if I wanted to read a newspaper, I had to pay for it. Why not? Why not? I will pay for it, yes, but then it's my choice which information is useful for me, and I will choose. But it's not the opportunity to simply dig into my privacy, not to protect fundamental rights, not even respect my privacy. So a lot of work is in front of us, and sometimes I'm frustrated after 5 years that not that much is moving. But to be honest, if I wouldn't continue to work on it, if you wouldn't continue, many of you continue on it, I'm also happy that the EDPS is always trying to put pressure. And I think we have to continue to make sure that in this digital world, we will not be lost in the end. Thank you.
Thank you very much. I think there's a lot to unpack there as well. I'm sure there are some reactions to that in the audience. I don't know if you want to intervene directly.
There's too much to say. But I think one thing where I would, being the only industry speaker on the panel, I would say that I don't think, in all frankness, this has been a big campaign on ePrivacy. So it's been notoriously one of the campaigns where Mrs. Sippel will have received the largest number of emails and meeting requests, et cetera. But I don't think that fundamentally, when you look at it, anybody has ever challenged the importance of having protection for the right of confidentiality itself. When you drill down and you go to the concerns, they're always on this aspect, which is relatively technical at the end of the day, which is the legal bases. Everybody that's concerned is concerned not about the principle of confidentiality and about finding ways to protect it. Most of the concerns are, frankly, all the concerns are about the fact that we are playing with the legal bases in a proposal that is broader than the current directive. And that does generate a lot of headaches when it comes to compliance. So I think the concerns are generic, and they are widespread. I've rarely seen a proposal where so many parts of industry, not just the marketing and advertising industry, have been concerned about the proposal. So that must tell us something. It cannot be that all of industry is evil and wants to follow people around stations.
May I directly add to that? It's true, no one ever is going against the principle of privacy, not in words, but in practice. If you look into all the many files where some digital aspects are in, we are always step by step getting away some of the fundamental rights. So yes, openly, no one will say, I don't respect the principle of confidentiality of communication. But in practice, this is happening, step by step. And I don't care for the legal basis. I don't care for principles. If you don't create binding rules, then the principle is worth for nothing. So you need binding rules. And I'm also surprised to say industry is against. To be honest, industry also was against GDPR. I heard many people say, oh, GDPR, that's evil. The whole economy in Europe will disappear. I'm going a little bit too far, but there were a lot of criticisms. And now it more or less works. There is still place for improvement because some of the actors are still trying not to respect GDPR, but it works. And even not to the extent we have created the rules, but worldwide there are debates around. And let's not forget, what I see is that more and more citizens are aware. And talking about industry, there are different parts of industry. There are even others who develop new models that are user-friendly, that are protecting fundamental rights. So we have to make our choice which rules we want to follow. And I will stop here because otherwise I will take another 10 minutes.
Thank you very much. I mean, it's difficult not to go into this direction of discussions with the proposal. It's so important as well. It's been there for so long. But I wanted to bring back the panel to the topic of governance and enforcement. And because, as we have just heard, the ePrivacy rules are more than just about cookies. It's about confidentiality of communications. There are all these links with the GDPR about consent, whether it's free or not. There's the unsolicited communications as well. I wanted to come back to Karin to ask you, in practice, when you have a case that is touching upon all these different issues, the line sometimes between ePrivacy and GDPR it's a fine line. So how do you draw that line and how do you approach these cases?
Yes, sure. First, it's important to precise that when we receive complaints, the plaintiff doesn't say on which text he or her refers to. Those people, they are no legal professionals, though the majority of plaintiffs that we have are individuals. They don't know ePrivacy, they know better GDPR. They only mention that they have a problem, they need help, and they don't base themselves, or they don't base the complaint on a text. So first, we need to understand what is the problem. Are we in the scope of ePrivacy? Are we in the scope of GDPR? What exactly the issue of the complaint? And in large majority, the plaintiff have no strategy in place. They don't know how to what they ask to which text to apply. The two texts do not deal exactly with the same thing. They have different consent. They have different material scope. So, of course, we need to apply one or the other and to use different procedure. When we have a cross-border processing, as French authority, if we are also lead supervisory authority, it's not complicated at all. I mean, we have a case, as I said, we make investigations, we find breaches of GDPR, we find breaches of ePrivacy of the French law on cookies, we find perhaps breaches of the postal code, electronic communication postal code on the prior consent for advertising, and we deal the case in all the same time. We prepare a draft decision, and the part of the draft that is about GDPR is sent to the one-stop shop mechanism applicable for GDPR. The part of the case that is an ePrivacy case doesn't fall under the OSS mechanism, so we do not share it. And at the end, we can issue and adopt the decision, the same decision. There are no two separate decisions. We adopt one decision with both aspects. One aspect with cooperation, one aspect without cooperation. If we are a concerned supervisory authority, it's extremely rare that we have both aspects. But if I think it happens very few times, so we split the case totally. We keep the case where we are competent for the French law, and we deal with this complaint. We investigate, and if needed, we make a decision. But if with the part that concerns GDPR, we send this part to the other authority, the lead supervisory authority. So the case is split. But really, it happens so rarely that I'm not sure that it happens twice, perhaps. In any case, the most important for us is to find a solution and to resolve the case of the plaintiff. We are talking about enforcement today, but we are really in a logical of compliance. As I said, we receive more than 40,000 complaints. We make around 200, 250 investigations. At the end, there is only, I say only, 15 or 20 sanctions. So the most important work is to try to solve the issue of the plaintiff and to have at the end to have compliance. It's a large part of the work.
Thank you. If I may, one quick follow-up question. In terms of splitting the complaint when you decide this is ePrivacy, this is GDPR, is there a harmonized approach to this among DPAs? Do you know what I mean? If the DPAs apply always the same criteria, so as you apply, have you agreed on which are the criteria among when you draw the line between one and the other?
You mean do other DPA do the same as us to split a case?
Exactly, and using the same criteria when choosing where ePrivacy starts and where GDPR begins. Because, for example, when one can think about, I don't know if you can hear me well because what I'm saying.
Very bad.
Okay, so when you have online advertising, for example, a cookie banner, of course, there's a clear ePrivacy, but there's also the consent issue, right? So do you have a harmonized criteria among DPAs when how to assess which part of the complaint you're going to be splitting with other DPA and what you're keeping? So what is ePrivacy and what's GDPR?
Oh, it's the scope of the text. I mean, there is ePrivacy is about the storage of information, the access and the storage of information on the terminal of the users. If we have cases with breaches that are out of this issue, we can have breaches of with retention period, information about something else. So we have breaches very clearly separate on processing. On different processing, so it's not complicated. I understand that you talk about
the consent aspect.
More processing, more.
Yeah. But don't worry, I understand. It seems that it's clear for everyone.
It's clear for us because there is that first operation that is the storage and the access on the terminal equipment. The other aspect is the subsequent processing of data for any purpose.
Okay, thank you. Arwid, you were talking about a gap before. There's clearly a gap. And we are talking also about how to fill that gap with the ePrivacy regulation. So with the current rules as they are, the current systems we have, ePrivacy, GDPR, how do you think we can fill that gap? What is necessary in terms, for example, of cooperation among authorities?
Yeah, thank you. First of all, let me make just a few general comments on what Birgit just said. I must say that as an attorney at law advising businesses, we are always saying to our clients that if your business model is not in line with GDPR, change the business model. Okay, but what seems strange to me is that people do not understand what's the real role of GDPR and ePrivacy, because this is not only about data protection and confidentiality, but it's also about fundamental freedoms, rights and freedoms. And for example, when you start profiling people, you must think not about the question of security of data, right? But about whether this processing of data does not lead to, for example, discrimination of people, right? So from this perspective, the role of, even in the title of the GDPR, it is not about personal data protection. It is about protection of rights and freedoms of people in relation to the processing of data. Okay, but coming to the conclusion on harmonization, let me just present a few general remarks, because it seems to me that what entrepreneurs, the business, and citizens expect from the law are, among other things, is predictability, consistency, and cooperation between, like we have in Poland, we have different authorities acting in the same area. So consistency in application of these laws by the authorities and courts. This is especially important in the case of the law on data protection and privacy protection, because we have a lot of interpretation doubts regarding the provisions of the GDPR and the provisions implementing the ePrivacy directive. In Poland, we have not adopted yet the European code, so we are still in the formal framework of regulation. But we are preparing to this, and there will be also new rules on ePrivacy when this new regulation will be adopted. Have we achieved harmonization in this area? I think that harmonization depends on many factors. The first is the form of regulation, especially whether we are dealing with a regulation or a directive that, of course, requires implementation. The GDPR is a regulation, but my practical experience as a legal advisor shows that the number of interpretation doubts has not decreased at all, because GDPR is very detailed legal act. And so comparing to the previous legal situation, I think we have still a lot of interpretation problems. I think that the enforcement mechanism in the GDPR is, despite some flaws, much better than in the ePrivacy directive. But there are several key aspects here. Firstly, it seems that a better solution is to concentrate competences and tasks from both scopes in the hands of one authority. That's what I was speaking about in the first part. The authority dealing with market regulation, interconnection disputes, frequency distribution, etc., always treats privacy issues as somehow additional to the main activity. In such cases, you need the authority needs a different knowledge, a different approach, because you have to remember about the role of ePrivacy legislation, which is broader than just confidentiality. Another issue is the authority's powers. I believe that the provisions of the GDPR giving the authority various powers related to the enforcement of the GDPR, like warnings, like reminders, and not only fines, are a very good solution. It gives the authority more flexibility in operation, day-by-day operation. Therefore, I very well received the proposal of a simple reference in the first version of ePrivacy regulation, of the simple reference to the provisions of the GDPR in this regard. It was stated simply that the same authorities are competent in ePrivacy area, and they have the same powers, because it was a simple reference to Article 58 of the GDPR. As we know, this has changed in the later version of the draft, as the supervisory authority does not have to be the only responsible for the enforcement, and the powers have not been regulated in the same way. I'm not sure if, from the point of view of harmonization, of this consistency, understood as coherent approach to similar situation, if such a solution will prove effective and good.
Thank you.
Thank you.
All right, so we have roughly 10 minutes left. I don't know if you have any comments that you really want to make in reaction to all that, or if you don't, I will just open the floor for questions. Alberto, Birgit, you want to say anything now? Or
Maybe I have one facetious comment on Karin's observation that it's clear.
Okay.
And I think I was giggling in the sense that I think one of the issues with the current directive and why we as industry want to make sure that the new regulation is indeed clear is that the directive is not clear. And that's, I think, why civil society has been complaining perhaps that the directive hasn't been enforced, because I think it's not clear in terms of its relationship with the GDPR already. And it's not even clear to the authorities. And Karin sort of said that. You know, it's only a few cases where we have a distinction in competence between ePrivacy and the GDPR. And so in the meantime, we have to remember the history of this, right? So ePrivacy is historically part of the telecoms framework. It was one of the 4 directives in the telecoms framework. Then the code came, and this is where the alignment was sort of lost also, because funny things happened when the expansion of the code happened. For example, the Commission forgot to add a legal basis to allow CSAM detection, and we had to do a separate piece of legislation to allow for that. And the same applies to Article 8 on cookies, where right now we have a little provision that started years after the original proposal in 2009, one little paragraph on cookies, and that's it. So it's not clear to the authorities, and the challenge going forward would be to make it clear so that whatever relationship we want to establish can actually work, both in terms of letting consumers know what they're dealing with. You said it very clearly. Consumers do not know that there's a difference between GDPR and ePrivacy. It doesn't matter to them. And when it comes to businesses, you're dealing with the same types of behaviors. So businesses want to know exactly, what are the rules? What is my fate? What do I have to comply with?
Thank you. From a consumer perspective, I have to say that as a kid, one of the things that my mother always says, don't accept cookies from strangers. And you guys keep trying to force feed us all sorts of cookies. But I don't know, Birgit, you want to react to that?
Maybe just a very short addition, because you mentioned CSAM and that the Commission forgot a legal basis. Now there is, you know very well, just to open another debate, there is the new proposal for CSAM, and it's quite interesting regarding the question if you really respect the principle to protect fundamental rights, that with the new CSAM proposal, what I'm missing in the legal basis is a reference to ePrivacy. So obviously we don't care in that area, and that will create, I'm afraid, some additional problems later on.
Thank you. All right, so we have a few minutes for questions. I see already Matthew, and then Michael, and then Kai. All right, so those 3. Please introduce yourselves, and if possible, say to whom you are addressing the question.
Good morning, Matthew Newman from MLEX. I've had the privilege to follow ePrivacy talks for the past 5 years. So, and I don't see any scope for this debate to be resolved anytime soon. And I was wondering, we see that the French government in particular, which has the presidency right now, has not been interested in really wrapping up this file, mainly over data retention. So it's a question for Birgit Sippel. I mean, she mentioned this. The council is pushing very hard on data retention and has put forward a proposal that is absolutely 180 degrees different from your proposal. So where do we go from here? Do we just admit defeat? Do we say, sorry, council, this is a non-starter? Or do we go to the commission and say, look, commission, 2017 was so long ago in terms of innovation, technology, it's just completely irrelevant what's on the table. Let's just give up and start over. Or we could follow what the CNIL has been doing, which is a very clear-eyed way of saying, look, let's just take the existing rules and make them better enforced, and that means a very clear reject all, accept all. Consumers understand it, businesses understand it. Let's just make it the rule for everybody. Is that possible?
I think
If I shall react directly, I think, first of all, if you compare the ePrivacy directive with the regulation, you will see that there are more details in the regulation. So it's good to have more harmonized rules on the implementation of the ePrivacy directive. But I think for the challenges in front of us, it's not enough. So we need a regulation. Also because in the directive, only telcos are regulated. And I think that's also unfair for the business world to keep all the others outside those regulations. Having in mind the behavior of the council, to be very honest, beyond the question that you mentioned, I had the impression that to some extent it's normal, but for ePrivacy it's partly a disaster. The interest was not that much on ePrivacy, it was more on other files like, for example, e-evidence. Regarding the question of data retention, let's be very honest, it's not my favorite idea. I don't like it. But on the other hand, we also know that the court did never say you can't do anything like data retention, but there are some clear rules. My personal position is, how can you create a legislation saying you have to protect confidentiality of communication, but at the same time talk about data retention? So that's two totally different sides. So if you want to have data retention, okay, but then you do need a specific law on this and not put it, by the way, into a regulation on this. So if the council would be ready to take data retention out of that file, I think that could make a big difference and lead to the effect that we can easier find solutions for all the other parts. Not that easy, but easier for all the other parts of the regulation.
Thank you. Michael?
Hi, thanks. Michael Veer from UCL. My question's about how the weaknesses of thinking in terms of confidentiality, given our current environment of control of our devices and computation. So we've seen a move from open PCs, fairly open browsers, to incredibly locked down operating systems, particularly in the smartphone space, where users and regulators have very little visibility into what is stored or accessed on these devices, and companies that run them feel they have the freedom to store and receive what they want from these devices. I'm not just talking about personal information, I'm also talking about all sorts of settings and updates and changes. In that environment, we see a move there towards using confidential computing to say we can get business value from analyzing data on devices, given that we control these devices. And we can claim it's all confidential and fine, but actually we'll be doing hyper-personalization on that device, tracking and targeting on that device, and so on. Can ePrivacy really help us go maybe beyond the GDPR here, if we understand what is storing and taking information from a device that individuals don't control? And how can that interlink with enforcement, given that we are in a very different world, also for smart home devices and so on, than maybe we envisaged of ePrivacy, putting a CD into a computer, hoping the CD doesn't rootkit your device so that it tries to enforce copyright and so on, which is one of the motivations behind some ePrivacy areas. So how do we balance that in GDPR, and what's the promises there?
Did you ask me or someone else? Okay.
So
Maybe I
Birgit?
will do some first questions. So first of all, in the ePrivacy regulation, we as Parliament at least, insist that we have to protect the integrity of the mobile devices also. And there is also an important question on where does communication start? Is it the moment when I put a paper letter into the envelope? Or is it in the digitized world the moment where I click send? Or is it even before that? And I think, personally, that communication and confidentiality of communication starts before clicking send. Because it's my communication, I'm writing down something that only a specific receiver should read. And that's important, that definition, because it also gives an indication to lawmakers, to companies, what they are allowed to do. And I think, therefore, a broad definition of communication is important. And I have the feeling that this is not respected. For example, I'm happy that everybody looks into it in the new proposals of CSAM, giving the possibility to go into communication before it's sent. But that's the end of confidentiality of communication. Because if you can look into it while writing, let's say it like that, so there is no confidentiality. And therefore, I think with the regulation, if we get the integrity of the devices, if we get a broad definition of what communication is, this could already make a difference.
From my perspective, I sort of disagree with the basic premise that it's a completely different world. If the stuff that you're telling me is happening on a device, even if you don't have ePrivacy, and admitting that stuff is happening, it's already illegal under the GDPR. So you as a consumer, absolutely, it is. So if you as a consumer have a complaint, you can already go to the Data Protection Authority, and it's their job to hear your complaint. It's already there. There's nothing, it's not a new world, it's already there. It is. It is. No, I disagree. It's GDPR. The rules are all there. And plus, there's other stuff that we know is happening beyond GDPR. So,
may I add a point? Because when talking about data protection, we very often talk about content data. How old am I? Which religion? All these things. But in these new digital world, we know that metadata also are very sensitive and can create a profile of persons. Mm-hmm. And it's even maybe the interest of the industry might even be bigger for those traffic data than for content data. Mm-hmm. Because for content data, you have to try to find out, if you find a technical way to understand it. Traffic data already exists in a technical standard. You can follow them. So a very, very easy, simple example, you do not need to look into my communication if I'm suddenly talking about a doctor or something like that. But if you find out by following my traffic data that out of the blue I'm contacting a doctor more regularly, this gives an indication about my private life. So when talking about the protection of data, of communication, of confidentiality, protecting privacy, we also need to protect traffic data, not only content.
Thank you. We are over time. We have just time for one last question, and it was already Kai who was asking in the. So please, short question, and then we're going to have to close, unfortunately.
Should I try
stand up?
Okay. 1, 2, 3. Okay, now it comes. Karin Kiefer, University of Frankfurt. Back in 2018, I think it was one of the testimonials to the ePrivacy hearing that was happening then. And then I claimed that confidentiality is relevant and also location data is relevant, and both is not really covered by the GDPR in the way it was used to be. There was another testimonial from somebody from Facebook who said, hey, this is all covered by GDPR, we don't need to worry, GDPR is good enough, and by the way, he was ascribing applications that nowadays you could probably translate into the metaverse. Facebook was still Facebook and not Meta then, and said we need these kind of features, we need these kind of services, and therefore ePrivacy would be a bad idea. So that was 2018. it wasn't really made clear why the metaverse was so important for the rest of the world that we should have no ePrivacy sensor, and I think that was also quite clear in the hearing. So now my question is, probably mainly to Alberto, partially to Birgit, is who is now actually blocking the GDPR? I think we still have no proper location data protection. We still don't have that confidentiality protection, so we have a gap. I think that's clear. What is now blocking the whole thing? Even everybody on the panel said we have difficulties with the current regulation. So who is it people who say who basically hinder the progress?
I'm not sure I understood the question completely. Again, it's very difficult to hear.
So I think who is blocking e-privacy regulation was the question? Or?
That was the question.
Yeah.
Because the strict argument that
I can tell you because I'm one of them.
I think I know who's blocking it, but
came from Facebook for saying it doesn't allow the metaverse. That was the 2018 argumentation there.
Now, and this is one of the frustrations that I have as a trade association that has a broad spectrum of members on this issue. Because the discussion is always on cookies and specific companies, which everybody likes to talk about. Okay, fine. I can tell you that during the council debates on ePrivacy, we as Digital Europe co-signed joint letters with 70-odd trade associations. And there you can find tech associations, but you can also find quite a long list of sectoral trade associations. So construction equipment associations are interested in ePrivacy. Car makers are interested in ePrivacy. You can go on. Why is it? Because it's not only about cookies and specific companies. The rules are broader. It's a broader discussion than we think. And a lot of companies are concerned because they will have to comply. You don't make a lot of noise about a file if what you want to do is hide and hope that enforcement will not happen. We are in this ePrivacy debate because enforcement will happen and we want to make sure that we do comply, everybody. So that's why, if you ask me, ePrivacy has been delayed so far. Because from the inception of the proposal, there was this simplistic idea that it was just about extending the current directive a bit. Well, no, it's a huge expansion and that does have repercussions because in the meantime, we have had GDPR. So I don't know what a lot of people think, why a lot of people think that there's this broad division. But the truth of the matter is that the overlap is huge. All the stuff that we're talking about, cookies, blah, blah, it's all already covered by GDPR. So if you're a company and I've done my GDPR compliance, okay? You can say there's no enforcement. That's a separate discussion. It's the data protection authorities that should go out and enforce. It's not my job. Don't ask me to explain why they're not enforced. It's not my job. But if you're a company, you want to be in compliance with GDPR. That's what everybody tells you, and that's what they've been doing. If all of a sudden I've done that, and I have to comply with something else that changes my legal bases, that's a pretty fundamental piece of compliance. And it's pretty disruptive for me that I can do something under GDPR that is perfectly fine, and I cannot all of a sudden do something that I should be doing, frankly, under ePrivacy. So that's why, because the interest is so broad, and everybody's been going to their national governments saying, listen, we are covered. You didn't think we were. You should look into the legal basis because this doesn't work for us. That's why the council has been dragging its feet, among other things. But certainly it's a major concern from the industry side.
Have to stop you there, Alberto. Birgit,
Just
you
to
have
add
closing words to
few
end.
words. I might not talk about all the aspects that play into that. But please remember from the very beginning when GDPR went into force, there were voices from industry, oh please, we have GDPR, we will do it, but not give us another legislation. And I also remember that from the very beginning there were voices that it would have been better to have only one piece of legislation, so to include ePrivacy into the data protection. Nevertheless, we are where we are, and I don't think that all the challenges are solved, even if best implemented. Not everything is already solved in GDPR. There are some explicit things where you need also the regulation. So some part is parts of the industry. Also, sometimes some of the politicians over different levels believe enough is enough. There is also an additional thing that the responsibility on national level is in totally different areas. Is it the Justice Ministry? Is it the Ministry for Economic Affairs? or is it the telco ministry? So it's totally divided, and therefore the interests are totally different. And in the end, it's also the political will, if the member states at this point now believe it's important, or if they like to concentrate on other points and believe other points are more important. And that's why I would shortly like to come back to my introduction, that protecting fundamental rights and make legal binding rules to make this happen are more important than ever.
Thank you very much. I think that's a good note to end upon. Apologies for the delay, but it was very interesting discussion, at least I think. So thank you very much for the speakers. Please a round of applause. And enjoy the rest of the day.